Good afternoon, everybody. Welcome to the next of our Essential series. These are topical, engaging, and technical webinars on wealth and wellness by leaders in the private client world. I'm Lottie, founder of the Jura Society, network and private client consultancy focusing on women, wealth, and well-being. Today, we're joined by Rebecca Bion from Forsters as she shares everything to do with digital assets and death. We're looking at estate planning in the 21st century. Please ask any questions in the chat. We'll have time for Q&A at the end, and the session will be recorded. Now, I'll pass you over to Rebecca. Hello, Rebecca.
Hi, thanks Lottie for the introduction. So just to explain, I'm a private client solicitor at Forsters LLP, specialising in estate, trust and tax planning for predominantly UK resident and domiciled individuals. And as Lottie has kindly said, this presentation is going to be on digital assets and death. So what are digital assets? They take many forms, and it's quite difficult to define them in a concise way, especially as there's actually no legal definition at the moment. But they are generally understood to be digital data, electronic records belonging to a specific individual, or that are accessed via a device such as a phone, PC, or laptop. So quite broad definition. So just to give some examples to put that in context, we're talking about photos, Kindle accounts, iTunes or Spotify libraries, social media accounts, so Instagram, Facebook, etc., text messages, email, cryptocurrencies, non-fungible tokens, so NFTs, PayPal accounts, and accounts with online gaming. So actually in preparing for this talk, I found out that some avatars and gaming points are actually quite valuable, and they're even sold often by online auction. So you get the idea, the list can go on and on and on. The main focus of today's talk is going to be the steps that you can take during your lifetime to ensure your digital assets, whatever they might be, are dealt with how you wish on your death, and that your affairs are left in such a way to make it easier for those that you leave behind. I'm not going to talk about how certain digital assets are actually taxed, as this could be a talk on its own, and it's a very emerging and specialist area and something that's being talked about a lot with HM Revenue and Customs at the moment. So what is the value in digital assets? In 2022, digital assets were estimated to be worth about £25 billion in the UK, which is quite staggering and is a value that's only going to increase over time. And as I've mentioned, more than you think may have a financial value. So I've mentioned avatars and gaming points already, but if you have a think about social media accounts that are used for the promotion of a business, they do hold a value. There is goodwill in the number of followers to that account, which, as I said, has a value. So it's important for business continuity, just as a practical point, to make sure that if you do have an account in the name of the business, it is in the name of the business and not a personal account in an individual name, because obviously that account might be redundant on the death of that individual. But there's also value in things like YouTube accounts, which often make money based on sponsoring posts, so advertisements on that YouTube account, which can create an annual income, which forms a basis of value. Digital assets also have more than just a financial value. They clearly have a pure sentimental value in a lot of cases, which can be equally as important on the death of a loved one. So this brings on to the next point. Why are digital assets unusual compared to other assets? And there's sort of three headline points. First of all, people don't actually own their digital content despite what they think. Second of all, they can't be accessed by personal representatives, so executors of a will, or personal representatives non necessity, so where you don't have a will in the usual way. And thirdly, because they are intangible assets, they often get forgotten when someone dies. So just to elaborate, first point, people don't actually own their digital content. There's a lack of legislation, which means that people believe or assume that their digital content is owned by them. But a lot of digital assets, so emails, social media accounts, etc., aren't quite an asset, but rather a license that will enable a user to access particular internet service providers' platform. So what this means is that the service provider owns the software and all of the intellectual property on their side. This leads into all sorts of issues. So if you publish content on one of these internet service providers' platforms, you actually don't own that content in most cases. So, for example, unpublished content doesn't get any copyright protection, which would enable you to formalize your legal ownership of the content you're producing. And what counts as an unpublished content is any content that's sent to only a number of people and not to the world at large. But with an Instagram or a Facebook account, you obviously control the number of individuals who can see the content that you produce. So it does count as published. Well, it is unpublished content and not public. And also personal data isn't considered to be an asset that can be protected via a copyright. So just leading on to a sort of another point in the fact that people don't actually own their digital content. Most organizations, so Microsoft, Apple, Facebook, etc., are based in the US, which means that access to personal information on their platforms is determined by complex laws in the US surrounding electronic communication and data protection. And again, that's a whole topic in itself, but the US are particularly careful when it comes to the release of personal information. And actually, if you think about these platforms, there is a lot of personal information that they do collect as part of their service about a user. And you can see why they might be wary of releasing information even after someone's death. And just to mention that the protection of personal information isn't something that's unique to digital assets. So, for example, the General Medical Council doesn't freely disclose a patient's files after they've died, as confidentiality actually lasts after death. And disclosure can only be allowed where required by the law, often with a court order. This follows through into these internet service providers' terms and conditions. So, for example, Apple's terms and conditions specifically provide that unless otherwise required by law, your account is non-transferable and any rights to your Apple ID or content within your account terminate on your death. Upon receipt of a copy of a death certificate, your account may be terminated and all content within your account deleted. So Apple are making it clear that unless required by law, on your death, and as soon as they get a copy of a death certificate, your account actually ceases and everything gets deleted. And similarly, Microsoft, their service agreement prevents a user from transferring your Microsoft account credentials to another user or entity. So you cannot transfer the information in your Microsoft email account to another person. That's simply not allowed under the terms and conditions. So in short, a lot of internet service providers' terms and conditions provide that accounts actually wipe after a period of inactivity or death or even incapacity. So it's quite important to remember that this might happen. And with this in mind, to have a think about what you would want to happen and what's allowable under the terms and conditions of certain internet service providers. And just to put this in context, there has been some very well publicized cases in the US on the issues that terms and conditions and non-transferability, etc., of certain digital assets creates. So, for example, in 2004, a 20-year-old Marine, Justin Ellsworth, was killed in combat. And his father sought access to his email account because he had been using his emails as a diary of his time in the army, in the Marines, sorry. And Yahoo declared that it was contrary to its terms of service to release the emails to Justin's father. And Justin's father sadly had to go to court to get an order forcing Yahoo to provide copies of all of these emails. Another example, so in recent years, Rachel Thompson has made very well publicized endeavors to obtain photos of her late spouse from Apple. And again, the terms and conditions didn't allow the transfer of those photos to Rachel. And so a court order was again required to force Apple to release the photographs. So these examples show that this is an issue, and there is quite a barrier towards obtaining digital assets on a loved one's death. So in summary, on point 1, a person might not own the content that they publish on an internet service platform, and therefore they can't obtain a copyright of that, and it doesn't pass as part of their estate. And secondly, the transfer of digital assets is often governed by internet service providers' terms and conditions, which are designed to comply with complex, often US laws around personal privacy. And those can make it quite difficult to transfer your digital assets on your death. And secondly, digital assets can be quite difficult to access. So I mentioned before, there's sort of 3 key points why digital assets are unusual. This is the second one. Ordinarily, when someone dies, their personal representatives step into the shoes of the deceased individual. And this means that they are then able to deal with any assets owned by the deceased as though they are the legal owner. So they take the place of the deceased individual. And as part of the post-death process for personal representatives, they apply for what's known as a grant of probate if there is a will, or letters of administration if there isn't a will. And that grant of probate or the letters of administration is then provided to banks or other organisations to make it clear that the personal representatives have that authority to deal with the deceased person's assets. And acting on that authority, banks and other organisations will release information about a deceased assets to the personal representatives, and they will allow access to those assets. So in the case of a bank, they will then release the funds in that account to the personal representatives to distribute according to a person's will. In the case of digital assets, this isn't quite accepted, and it's not the case just yet. So for cryptocurrencies, there is no bank or organisation to send grant of probate or letters of administration to. And even if there were, a lot of the information that they would require comes in the form of passwords, usernames, passkeys, etc. And actually, the grant of probate obviously doesn't contain that information. And so these organisations won't just act on a grant of probate. This is not the process that's developed thus far. And to give an example, again, on the problems with losing passwords, usernames, passkeys, or not having access to those, you might have heard of the case of James Howells, who lives in Newport, and about a decade ago threw away a hard drive which contained the passkey to his crypto assets, which he currently says would have been valued at £227 million at the moment. And he basically just binned his hard drive, he says accidentally, and he's had problems with Newport Council getting them to give him access to a rubbish tip to enable him to search for this hard drive. But the problem is, without that hard drive, he doesn't have the passkey, and he just has no access to those assets. So obviously this is quite unusual compared to most assets. So essentially what I'm trying to say is that without passwords and usernames and passkeys, even if personal representatives have a grant of probate, they may simply face a brick wall when they're trying to access those assets on a person's death. But then this leads into another point. So it's not simply a case of then sharing your password or usernames or passkeys during your lifetime with your personal representatives. Aside from the fact that there are obvious risks when you share this information during your lifetime, just because that information can be used to access assets illegally or without your permission. Actually, sharing your passwords can also in itself be illegal. So under Section 1 of the Computer Misuse Act 1990, which was actually designed to stop computer hacking, and I don't think it was ever intended to apply to this situation, a person is guilty of an offence if A, they cause a computer to perform any function with intent to secure access to any program or data held in any computer or to enable any such access to be secured. B, the access they intend to secure or to enable to be secured is unauthorized. And C, they know at the time when they cause the computer to perform the function that this is the case. So just to summarize that section of the legislation, authority under B, so the authority that is unauthorized, the access that is unauthorized, that authority comes from the internet service provider, not from the user. So it would be with Microsoft's authority that a password is released. And in effect, what this means is that if you share your password without Microsoft or Yahoo's, etc.'s authorization, you are acting in breach of the law. So you can see where the obvious risks of that are for personal representatives or even a user during their lifetime. As I said, the legislation is intended to provide a means of prosecuting hackers and not personal representatives managing a state, but it is a risk. And lastly, I mentioned before, there are 3 reasons, again, why digital assets are unusual. The third one is that digital assets can often be forgotten. They're obviously quite new and intangible and not often thought about as having a value. But also, if you think about your daily lives, you can probably sign up for quite a lot of accounts at the click of a few buttons in the course of an afternoon. So you can see why these types of assets could quite conceivably be forgotten. So unless someone has very clearly told their family about their digital assets and their personal representatives are aware of them, they can obviously be very easily missed when it comes to administering an estate. So in summary, digital assets are unusual because people don't own their content. They just don't own the digital content. 2, they cannot be accessed by personal representatives on a death in the usual way. And 3, they can often be forgotten. So with all of that in mind, what can you do now in order to plan for your death and to account for digital assets on your death? I should say watch this space. The US and Canada have introduced legislation to allow personal representatives to access digital assets. But as yet, the UK hasn't followed suit. So this is an emerging area, and there is hope that the government will start to have a look at this as an issue, but it doesn't seem to be at the top of their priorities right now. So step 1, you can review the assets that you have and the information that you hold online. This helps by assisting your personal representatives, because actually, if you have all of this information written down in a secure format that can be provided to your personal representatives on your death, it will make their job so much easier. So this includes the accounts that you have online, what is stored on those accounts, what your subscriptions are, what your devices are, how those devices can be accessed, where they are physically located, if they're phones, laptops, etc. And all of this information can be stored in the form of an inventory, which has all of this information down. Obviously, having everything in one place can be quite dangerous or difficult. And so the following caveats should be borne in mind. So that inventory should be reviewed every 6 to 12 months, especially as we're often asked to change our password on quite a regular basis. The inventory should be stored securely and not shared. So aside from not wanting the information to fall into the wrong hands, as I mentioned before, you have to remember that it's illegal to access information without the authority of a particular internet service provider, and to facilitate someone else's access to an account by providing that password to them. So what you could do is to have this information in an accessible format, but stored securely, perhaps with a professional advisor who would put it with your will, or to keep it somewhere at home that can easily be found on your death. And by keeping it at home, then you don't need to get a professional advisor involved every time you need to update that list. Or you could use a password manager with a master password, which lists all of the information and passwords, etc., on that password manager. Or you could employ a third-party digital asset custodian, or you might have multiple digital asset custodians to eliminate a problem in the security of one of those organizations. And actually, custodians often store private information, the passwords, etc., of asset owners on hardware that is physically stored in a vault somewhere. So it's quite secure. Step 2, you can update your will. There are quite a few things that you can do to update your will to account for digital assets. So first of all, you can make a specific gift, a legacy of those digital assets to particular individuals. This has the benefit of highlighting in your will, first of all, that there are digital assets that the personal representatives need to account for. Secondly, you may not want your digital assets to pass to your residuary beneficiaries. And just to elaborate on that point, in a will, you might make specific gifts of, say, £1,000 to Batty Cats and Dogs Home, etc. And then you would say that after settling tax liabilities and paying out those legacies, everything called your residue gets divided between certain individuals. That might be children, for example. And actually, if you don't want your digital assets to be divided in certain proportions amongst possibly a number of individuals, you'd want to make a specific gift, like a legacy, as I said, that the money to the Battersea Cats and Dogs Home, to a specific individual. You might also include in this provision in the will a specific power making it clear to any internet service providers or other organizations that your executors, your personal representatives, have got the power to access and control digital assets. Now, obviously, it depends on the terms and conditions of a particular internet service provider, what they will actually do, but having this on the face of the will can be very useful. Secondly, you might include a provision about chattels. So chattels are tangible personal possessions, so jewelry, laptops, mobile phones, paintings, etc. You get the idea. And ordinarily, chattels are left specifically to certain individuals by a clause that's agreed across the legal profession as being helpful to describe these chattels. But the wording of this clause only deals with tangible personal assets, not intangibles such as digital assets. And this can lead to problems, because if you make a gift of your tangible assets, that would include your laptops, mobile phones, etc. And those items are the means of accessing the intangible digital assets. So you could end up with the access to assets being split from the actual ownership of those assets if you're not careful. And this also leads to another problem. If digital assets are to go one way and the physical access to those assets another, then you might end up with someone you don't intend to have your digital assets having access to them. So just as a practical point, personal representatives might consider wiping a hard drive before handing over a laptop to someone who shouldn't be getting digital assets. Step 3, you can check to see what providers actually have discretionary arrangements. So discretionary arrangements are those where a company allows the transfer of digital assets as a matter of goodwill. So Twitter, for example, allows a person authorized to act on behalf of an estate or a family member to request deactivation of an account. Apple allows access to data, photographs, and notes stored in the cloud to a named legacy contact who's specified during lifetime. Facebook's terms and conditions allow 3 options: memorialization, removal or deactivation of an account, or the appointment of a legacy contact. And the legacy contact can only be an immediate family member or a personal representative. Google allows a person to nominate an inactive account manager who gets notified if an account hasn't been accessed for a period. And that person might be able to receive data or even have access to an account. If no one is specifically appointed as an inactive account manager, then it's at the discretion of Google whether they allow access to an account. Avios points, you can appoint someone who receives Avios points on someone's death. It's again at Abios's discretion, but often when a solicitor provides a grant of probate, they will transfer Abios points to a beneficiary's account. And Tesco and Clubcard points actually can be transferred to another Clubcard or Nectar account at request. And lastly, and this is the end of my presentation, you can back up and clear out files. So if you have photos that you're uploading to Facebook, Instagram, etc., or emails that are important, print them out, back them up, have them on your laptop. And if there's anything you don't want anyone to have access to, delete them. Make sure that they can't be accessed by someone who possibly inherits your laptop. So that's it. I hope I've given you an overview of the problems with digital assets, why they're unique, why they need to be dealt with differently to other elements of estate planning, and some practical points. But as I said, watch the space. These are just practical points for now, and hopefully there'll be more legislation in due course to make the position much, much clearer. Are there any questions?
That was brilliant. Thank you so much, Rebecca. Fascinating. And I think that we all definitely need to be better at record keeping, whether or not it is digital assets or tangible assets. I think that's one of the key areas, and where somebody like you can come in to really support anyone who's feeling overwhelmed with actually quite a substantial task. Because as you say, we so easily sign up to things on an afternoon without realizing actually what the repercussions might be, either in terms of access or value. Brilliant.
I think it's quite difficult in your mind also to get your head around the fact that you don't own your social media accounts that you put your life into.
Yeah,
it's a very strange.
Well, and I think there's a lot, with content creators now, with being very aware of the risk that they're putting for their livelihoods on these platforms that could actually either be shut down or hacked quite easily, or taken over or something like that. There's a lot of people who get their accounts ransomed because of the value for access to their followers, for instance. It's a whole new world we're entering into. I'm wondering as well whether they'll end up being almost sort of a graveyard of lost digital assets at some point, like a left luggage space where you have to come and identify them.
I mean, there are things that you could do for tangible assets. So there are searches that you can do after someone has died to locate bank accounts.
Yes,
people might have opened a bank account and had £1,000 in it and just forgotten about it. I wouldn't, but some people do. And there just isn't that record keeping. The digital custodians of certain digital assets.
How could the blockchain come in to help with this, or is that totally sorry, I'm just going off on tangent here.
No. It's in all honesty, crypto assets very much confuse me. But I understand that they're trying to regulate that area a lot more so that there are specific record keepings. Everything is kept in a clear and accessible place. But there's obviously a lot of back and forth, and actually regulation brings about controls that I'm not sure a lot of blockchain providers want to be involved in. But it's such an emerging area. It's fascinating.
And especially when you've got sort of biometric data access as well, so you need fingerprints to access it. What are you going to do? Make a copy of the corpse's finger? I don't know.
Hopefully it doesn't come down to that.
Yeah, but imagine, cartels probably have already figured that one out. But anyway, any closing points you'd like to make?
No, I think the only closing point is just remember that there is more to estate planning than I think people see in the movies. We don't do will readings. We do take detail quite boring instructions about exactly what you own, and just when you are thinking about doing your succession planning, just have a broader mindset of what do you want to achieve, what do you own, what are these assets that are slightly strange that you might not think have financial value, but sentimental value is important. And just come prepared when you speak to your solicitor about your estate planning. have it all written down. And the reason I mentioned will readings don't actually happen is you never have people in a room after a death saying, you get this, you get this, you get this. So actually, you don't always have the input of family members at that point in time, and you don't have people saying, well, actually, Auntie May did have, you know, this world famous Instagram account or something like that. It's up to you really to make sure that this information is available and accessible to people on your death.
Why don't we do will readings? Sorry.
I think they're just very dramatic for movies, but we don't do it because a will is a public document. They get published on the probate registry, and you can download one for £9 if you like. So I think there isn't that shroud of secrecy that's implied in movies about what happens in someone's will.
Weird that they came up with that.
Well, I wonder whether it happens in the US. I don't know. And a lot of movies, but the amount of people who've asked me, you know, when is the will read? And saying, here's a copy.
There you go. Your digital asset.
There you go.
Brilliant. Oh, well, thank you so much, Rebecca. That was really eye-opening, and as you say, there's so much more yet to come. So it's all about, you know, being vigilant and trying to mitigate risks that you do know you can do to start with, and making sure that everything is documented as accurately and as delicately as possible.
Yes.
So thank you so much for being here. Thank you to everybody who's tuned in here on LinkedIn, and for everybody who's going to be watching the follow-ups as well. If you've got any questions for Rebecca, please do contact her. I'm happy to put you in touch as well. But again, thank you all, and have a super rest of your afternoon.
Thank you. Bye.
Bye-bye.